Good afternoon, ladies and gentlemen. My name is Prince Dayo Fadino. I reside in London and I've been practicing in London for well over about 25, 30 years. Today, what I have in mind today is to try to educate and enlighten my fellow brothers and sisters on various immigration rules and regulations, how you could truly and really make use of these rules and regulations, and how it could benefit so many people whom I know over the years do not just know what should be done when it comes to their rights and the rules and regulations of this country. As I speak, I'm aware of the fact that there are hundreds of thousands of Africans, Asians, people belonging to various ethnic minorities who do not truly and really know their rights in this country when it comes to the human rights and immigration rights in this country. What they do is I know so many people who have been living in this country in fear, not knowing where to go and where they're going, and they live in this country in fear for 10, 15, 20, even more years, not knowing what their rights should be or what they should be doing to be able to resolve their immigration problems. So I hope today the rules and regulations I'm going to be going through and ways of actually resolving immigration problems would help immensely, and would at least guide so many people to know where they should be going and what they should be doing if they should have immigration problems in this country. And I would want to hope that after the short speech I'm going to be giving, if there are going to be a few people who would want to actually throw questions to me concerning maybe their unique immigration problems, or people they know who might possibly have those type of problems, that those people should please be free and feel free to at least ask the questions they want to ask after my speech. Now, I'm going to be starting off with one particular area of immigration rules and regulations that so many people are not aware of. These rules and regulations were promulgated, I think, in 2012. This was when Theresa May was the Home Secretary. I think the rules came into force on the 9th of July 2012. And those rules were mainly to do with people who have been living in this country or who have been overstaying and who, for one reason or the other, could not renew. For one reason or the other, could not renew their immigration papers and started overstaying in the UK. Now, this particular rule is normally called Rule 276. Rule 276 ADE, and that rule covers about 4 or 5 areas of people who have been overstaying in the UK. And if they were staying for a while, and they fall within the categories I'm going to be laying out, they might be able to at least apply for leave to remain in the UK. It's normally called limited leave to remain in the UK, and it will then give them that right to be able to stay in the UK. Now, the first area of this Rule 276 ADE that we want to actually mention is that first aspect of it is called the 7-year rule. The 7-year rule. And this 7-year rule is mainly to do with children who are born in this country. So, in effect, if you've been staying in the UK and you gave birth to a child in the UK, or if you have children who have been in the UK for 7 years, you could then make use Hello. Yes, thank you. If you have a child who was either born in the UK or was brought to the UK, and that child has lived in this country for 7 years, if the parent or parents have been overstaying in the UK, you could then make use of that 7-year rule. The fact that that child has been living in this country for about 7 years, or born in this country and has lived in this country for about 7 years, you will then be able to at least make use of that rule to apply for leave to remain in the UK. So as far as that particular rule is concerned, so long as you've not committed any criminal offense, even if you've been overstaying, it will not matter. You should be able to make use of that rule to be able to remain in the UK. So if there's anybody who falls within that rule, or who knows of anybody who has had children in this country and that the children have been living in this country for 7 years, but that child was born in this country and lived in the UK for 7 years or more, that person will have to be a child up until the age of 18. That person should be able to make, or the parent should be able to actually make that application for limited leave to remain in the UK. If that application is granted, you will be granted 2.5 years. And before the end of that 2.5 years, that parent will then be able to apply for an extension of leave to be able to stay in the UK for another 2.5 years. You need to remain in the UK for 10 years before you can then apply for indefinite leave to remain. But as far as the child is concerned, that child, after you make an application for leave to remain, and that child has now been granted leave to remain, a year after you've been granted leave to remain, that child will apply for registration to become a British citizen. Right? So anybody who falls in that rule, yes, I might be able to look into that possibility and do something for that person to leave to remain. If that person has been overstayed in the UK. The second part I would also want to mention is if we have a parent or two parents, right, and they're not married, but one of the parents is a British citizen, right? Whether the couple are married or the couple is married or not, right? So long as one of the parents is a British citizen and they have a child, so long as one of the parents is a British citizen and that child is British, the parent who is not British or who has been overstaying in the country for God knows how many years, so long as that person has not committed any criminal offense, the parent who is an illegal person will be able to make use of that British, the child's British citizen status to be able to apply for leave to remain in the UK. With the child and possibly the wife or the partner, even if they're not married, or even if they're even living apart, so long as each one of them is contributing to the maintenance and upkeep of that British child, and it's on record that either the mother or the father, who is not British, is always contributing or doing things to that child, maintaining that child, making sure that the wealth of that child is very, very well and good. That parent could then use that British child to apply for leave to remain again. It will be limited leave to remain 2.5 years, and then after 10 years, that parent will then be able to apply for citizenship. The third category of the Rule 276 AD is called the 20-year rule. The 20-year rule, what it means is if you came into the UK 20 years ago and you've either been overstaying or you came in with no papers, and you've not committed any criminal offense, and you've been, you've not actually been exposing yourself to authorities for about 20 years, and you could show in the last 20 years that you've been living in this country, in the UK, and but the only aspect of this rule is there are so many people who might not be able to make this rule for one simple reason. There would have to be documentary evidence of the fact that for each of those years, you've been living in the UK. Take for instance, like college, documentary evidence of maybe schooling, college, medical papers, even work. If you've been working, even if you've been working illegally, or you could show that you've worked in the UK for that period. References from people who actually know you. Take for instance your church members, a pastor, a doctor, somebody who is quite high up there in society, a civil servant, writing a reference letter to the effect that we know you, that they've known you for for a number of years, or so many years. So long as you could prove 20 years of living in the UK, you would be able to apply for limited leave to remain. Again, it would have to be within the remit of you not, the fact that you've not committed any criminal offense, apart from just overstaying, you should then be able to make an application for limited leave to remain. As the two other categories, you'll be granted 2.5 years leave to remain, and you would have to renew for another 3 times, before you could then apply for indefinite leave to remain. That will be after 10 years from the date you were granted the first 2.5 years. There is also another category of if you are married to a British citizen and you've been overstaying, if you are of good stance and good state to society and you've not particularly done anything very serious and damaging to society, you should be able to apply for limited leave to remain again, on the basis that your British spouse would find it very, very difficult to be able to settle in your country of origin, or maybe that person who is a British citizen is maybe taking care of somebody elderly or taking care of a minor in the UK, and there will be insurmountable obstacles for you not to be able to return to your country of origin with this British citizen. If you could prove and put all the documents together to show this, you should be able to at least make an application for limited leave to remain in the UK again. That situation again is for 2.5 years. 2.5 years multiplied by 10 years. After 10 years, you'll be able to then apply for indefinite leave to remain. The next category under Rule 276 ADE is normally called, it's a situation where if you are in between the ages of 18 and 25, 18 and 25, and you've actually spent more than half of your life in the UK, it's mainly to do with younger people who are they are above the age of 18, but in between the ages of 18 and 25, and you've lived in the UK for more, even a day, just a day, more half of your life, a day above, that young person would be able to apply for limited leave to remain in the UK. Again, there are so many youngsters who fall within this category that either do not know what they should be doing, or just decide to at least stay put and stay quiet and not talk about these things. And before they know it, they continue to overstay and they would have possibly even done their college in the UK, maybe university, working, but the fact that they do not have the right papers, they would not be able to progress and do much with their lives. if any young person is within that category, 18 to 25, that person should be able to make an application for limited leave to remain. Again, a 2.5 year, the first 2.5 years will be granted. You will then be able to move on and do what you need to do. For every 2.5 years, again, 2.5 years multiplied by 4, that's 10 years. After 10 years, you'll then be able to make an application for indefinite leave to remain. There's also, under that very same category, we also have what's called a person who has lived in this country for less than 20 years. That means, you know, I mentioned the 20-year rule whereby you've lived in the UK for 20 years or more, but in this instance, it will be less than 20 years. For that less than 20 years, there are so many conditions and requirements that you would have to fulfill, because it's very stringent, very strict, and it's always very difficult to at least make this application, but it's still possible. And what the application entails is this: you need to show that there will be insurmountable obstacles. Take, for instance, if you've been in the UK for 6 years, or 10 years, or let's say 18 years, 19 years, not 20, less than 20 years, you then need to show insurmountable obstacles why you will not be able to go back to your country of origin. There are times it could be a situation where we have a situation with family in Nigeria. I'm sorry about this. We have a situation with family in Nigeria where you think that your life is at risk, and it's proved to the effect that that's the situation, or you feel that if you should go back, it could be a situation where that could be likened to an asylum situation where people are applying for asylum. This is not actually an asylum application, but it's a little bit close to where you could be persecuted back home if you go back home, or treated badly if you go back home, or there's a situation where things will just be terribly hard and it's so difficult. You are now used to the UK, you can't go back. But the situation you then need to prove is that insurmountable obstacles, exceptional, compelling, compassionate reasons as to why you need to stay here, and there's evidence to that effect. You should be able to make an application for leave to remain if you've been in the UK for less than 20 years. So I think I've mentioned this. Yes, there's also another situation where you've been in the UK for so many years, but they are compelling, they are most exceptional, compelling, compassionate circumstances why you think that you should remain in the UK. Maybe the family ties, you've been here for so many years, it could be likened to the 18-year rule, but this would be a human rights, it's normally called a human rights application, where the circumstances and the situations and and what you're going through in the UK are so very compelling and compassionate that there's no way you could go back. Take, for instance, if you are taking care of somebody in the UK and that person is so dependent and reliant on you, maybe a sick relative, or even a very, very sick, very close family friend, and there's evidence of the fact that you are the person taking care of this person, for instance, and that person is so attached to your care, and the fact that that person is very, very dependent on you. Yes, under the human rights rule, your right to private life, your right to possibly even family life with this family member, or a very, very close family member or family friend, you should be able to make an application based on the fact that it's a human rights application. That's also another possibility. We also have situations to do with asylum applications. There are various asylum applications that can be made in the UK. The first one is to do with your fear of persecution due to political reasons. You would remember the time of when in Nigeria, for instance, when we had a situation to do with the Abacha regime, when so many people are leaving Nigeria because of the terror, that reign of terror of Abacha, the Abacha regime in those days. If you come to the UK, you could claim asylum at port of entry. But we don't particularly have that kind of situation in Nigeria any longer, although there are still a few political persecutions. Even despite the fact that we are running a democratic dispensation these days, they could still become some extreme cases where people feel that they fear persecution and they leave a country like Nigeria or even Ghana or any country for that matter. It shouldn't just be Nigeria. You should then be able to make an application based for political reasons. You could also make an asylum application for religious reasons, where you feel that you're not safe in a place like Nigeria, Ghana, or any country for that matter, where you have so many religious, tendencies in the country, where there's that tension to do with, for instance, Muslims and Christians, where I know for sure, take for instance, in some parts of the northern part of Nigeria, and take for instance like Kaduna, where you have a significant number of Christians or places like Jos or Makurdi, where people are being persecuted by Muslims. If they conclude that they're not safe, that they're not being protected by their own police, and that they could show that there are so many people who have been murdered and killed, and they've not been protected, such people could claim asylum. But they would have to be very, very strong proof that they're not protected at all, and that they've done all they could to seek the assistance and help of the authorities, but nothing actually came out of it. Such people could also claim asylum. You also have claiming asylum for social reasons. It could be to do with discrimination. It could be due to a person's sexual orientation. It could be due to so many other things to do with social reasons. You could claim asylum for that. There's also the bit I would also want to touch on to do with work permits. The work permit situation is very, very intense and very wide. You've got so many categories of where you could at least apply for a work permit from Nigeria under either the tier 1 or tier 2, or from any other country apart from Nigeria. You could apply for that very particular work permit. But these days, many of the work permits have been restricted because I think so many nationalities are abusing this work permit, the work permit applications by lying, by not actually disclosing material facts and all that. So they've particularly restricted people using the work permit avenue to actually come to the UK. But it's still there if you meet the rules and regulations to do with that work permit to be able to apply to come in. I'm talking of people like teachers, nurses, medical doctors, some scientists, particularly the teachers, especially if you are tutored and very specialized in subjects like mathematics, science subjects, chemistry, physics. Many people are making use of that very particular avenue to come to the UK, but you would have to be a very experienced teacher, and you'll be interviewed at the various consulates and embassies from the country you are coming from. And because this country, they are very, very short of those areas to do with teaching. Information technology is also a very good area, where if you are very experienced in teaching in that area, you could also make use of that. Certificate of sponsorships, you would have to, at least the employer would have to apply for that for you. If there's a shortage in a very particular area of work,
can you help me fix this?
And they feel that you are going to be useful for them, whether the moment you finish your studies, and you are, these days, there's what's called a 2-year work permit. If you finish university education, either your first degree or your master's degree, you could then make an application for leave to remain for 2 years to work in the UK. It's normally called a 2-year work permit visa. Before the end of the 2 years, you might then be lucky enough for that employer to want to take you on full time, and that employer will then apply for you to continue working with them. So that's also possibly another area you could look into. I also want to briefly touch on the issue of naturalization. Before the 10th of February this year, if you've been granted indefinite leave to remain, after about a year, you could then apply for naturalization. But after the 10th of February, there is now a new rule to do with applying for naturalization in the UK. If you came into the UK illegally, whether you used other people's papers or you came into the UK, just smuggled yourself into the UK, through the back of the lorry or anything, and you've now been in the UK for a long time, and you've then applied for indefinite leave to remain, and you've been granted that indefinite leave to remain. After the 10th of February, that person, whether you've been in the UK for 3 years, 13 years, 30 years, right, and you have leave to remain, you would not be able to apply for naturalization. So that's a change to do with the Nationality Act. You would not be able to apply for that for that naturalization. You will still be able to hold on to your indefinite leave to remain, but you will not be able to apply for naturalization anymore. That rule was changed on the 10th of February this year. So that's one area I would also want people to actually be aware of, because it's not possible anymore. Although I emphasize the fact that there might be some challenges, legal challenges on that in that respect, because the fact that somebody before the 10th of February would be able to apply for indefinite leave to remain, naturalization, then all of a sudden they decided to change it. I could see people challenging that very particular rule and making the case that, hold on, the fact that somebody came in illegally so many years ago and that person is now established in the UK, possibly doing so well, contributing to society, maybe that person is a surgeon, for instance, or a very good lawyer, or a good engineer, contributing very heavily to society. Why should that person then be deprived of citizenship, especially if that person has proven to be a person of good character, a good citizen? So I could see challenges in that respect. But as of today, if anybody if anybody falls within that category and applies for citizenship, that person would be refused at this point. And then depending on whether you want to now challenge it or whether you want to go via judicial review, depending on that person's special circumstances, the person should be able to at least challenge that situation. But that's the case for now. The person will not be able to apply for naturalization. There are also areas to do with elders. I know of people who have been who came to the UK as visitors, elders, and they came with a visitor's visa, and the rule is very clear about visitor visas. If you come in as a visitor, you come in for the purpose of just visiting. That's what that visiting visa, that's what it entails. But you then have a situation where maybe an elderly person came to the UK, elderly parents, and one of the parents is seriously ill, and that elderly parent would not then be able to go back to his or her country of origin. It's with his or her daughter or son, who are the parents, and sorry, with their son or daughter who are taking care of these parents. It is, I mean, that person would or should be able to make an application based on very compelling compassionate grounds. That look, if this person is so ill that there's nobody to be able to at least take care of this person back home, and the person is so dependent on us, so we need her to at least be able to remain in the UK based on compelling compassionate grounds and based on a very particular article called Article 8 of the European Convention on Human Rights, which allows that right to establish family life with your family member in the UK. You should be able to make an application. Those parents should be able to make an application based on that kind of situation. So those are the areas I feel people are not particularly very clear about. They could also look into situations where if indeed you feel that you fall within any other category you think it could be very, very worrying and all the rest of it, please, I'm here to at least address that very particular situation. But for now, those are the areas I feel people should be looking at if they fall within those categories and they feel they would want to make use of these categories to apply for limited leave to remain. So for now, if I'm not sure whether there are other areas people think they would want to at least pick on my vast knowledge on it, or if there are other questions they would want to actually ask concerning all what I've actually mentioned so far.
Thank you very much, sir. So much knowledge. Please, if you have any question, you can ask in person. Yes. I know. You can ask in person or write it down in a sheet of paper. It will all be addressed.
Praise the Lord. Praise the Lord. Okay, so while we wait for speaker to continue, do we have anyone that has any questions? Okay.
Praise the Lord. Thank you very much, sir, for the information shared. The question I want to ask is on spousal visa. I have a young man who is about finishing the postgraduate study visa, 2 years. Now he's engaged to a lady who is a citizen. They've gone to court, but the day they gave them, sir,
They said they've gone to court.
They've registered to be married. So the date they gave them, it will be a week before this guy visa expires. I mean, the day they will be married legally and to get all the ahead. So I'm asking, sir, do they really have a chance? Because if they will be given certificates, I like they will get the certificate that same day, and it's a week to his visa being expired. Do they have chance to still apply for spousal visa? Then the second one, sir, does that guy, is there any other application he can make to stay? Because it's fine somebody who wants to get married.
All right, so thank you very much. So the person, the British citizen,
Yes, sir.
the lady, okay, he is a student.
No, the lady is a citizen working already.
All right, but he is a student.
No.
He did
The guy has finished
his studies.
working.
Okay.
Postgraduate study, what do they call it?
Post, two-year post-study.
Yes. So he's working.
Okay, he's working, okay. The wife, is the wife working?
Yes.
On what salary is the wife?
Oh, that can't really answer, sir.
Because the rules changed also slightly to do with spousal visas. In the past, so long as you could show that the spouse is earning, I think it was 18,900 or 700 or something, I can't remember then. But those rules changed, I think, last year, where instead of showing 18,700, it's now about, no, it's 28, I think 28, nearly 29,000. 29,000. So if the lady is not earning that amount of money, any chance of children in between them right now? No. They just engaged. Okay. If she, I mean, we need to clarify the salary bracket of the wife, right? And we also need to clarify whether that spouse, the British citizen, if she's not earning enough, she has enough savings, to be able to at least make up for if she's not earning enough, right? So, yes, the application could still be made. You said about a week before.
Because we are the ones they will give them dates if they want to register for country wedding, all these things. So the actual date they give them is that month that the visa of the guy will expire.
So what month is it?
May. So
okay.
They've been looking for a place that will be earlier, but they couldn't get. So they gave them. It's a week.
Okay,
a week
gap.
To the time that the guy visa will expire. So I'm not saying, is it possible to still apply for?
You could still apply, but the point is technically, the man, if you apply after the dates, the man's visa expires.
They still
right?
have a week.
No, you said, is there any case they could apply after? Is that the question?
No, what I'm saying is that, do they have chance? Since it's a week, could they still make it to apply a week to the time?
Oh, yes.
Okay.
I mean, so long as that visa is still, running,
Yes, sir.
it's still extant running, they could still make the application. But if they are to make the application on the application form, because most of these application forms are now they're online.
Yes, sir.
But you see, in that situation, they would need technical advice. Somebody a lawyer or somebody who actually knows. That person doesn't have to be a lawyer, but if you know what you're doing,
Yeah, okay.
that's very, very important.
Yes.
Because many people just do this. When they are making the application, there's a very particular column or part of that application where they will be asking for more information to do with, do you have anything else you want to actually say about the application? You then lay out the reasons why you are making the application this late. That, take for instance what you told me, trying to find a place to do the wedding and all the rest of it, and that you've only just got this date, this which is stated this very particular date, and this visa is expiring a week afterwards. If you do that, I think they should be covered, because normally they should be making the application at least a month before the expiry date of the gentleman's visa. But if there are special reasons and special circumstances as to why they could not do it earlier, it will be laid out in that particular form to do with the application they're making. So it's possible, yes.
Thank you very much, sir. Does this guy, is there any other application he can make for stay? Apart
I don't know.
that, is there any other, I don't know.
Well, I don't know of his special circumstances. So because of, if I don't know.
After 2 years postgraduate, does anybody
I can't find any other. Well, apart from the apart from the wedding, apart from the marriage, right? There could be other reasons. I don't know. I don't know of this gentleman's full circumstance or full immigration history. There could be situations where I don't know. Take for instance, if he's poorly, if he's not well, I pray he is. But if it's not well, there could be situations where you could make an application based on that. If there's a situation where he has a child who is British, I mean, or what I mentioned earlier and all the rest of it, So because I don't know of this person's full immigration history, I would not. But the marriage is one thing, yes. Other reasons, for now, going by what you've told me, the limited information you've given me, I don't think there is any other way you could actually make an exit. You can't extend a 2-year visa now.
Praise the Lord. We're aware that some people might not want to speak, so if you have questions and you prefer to note it down, let us know. Any more questions?
Thank you. Thank you, sir. For elderly parents on visitors visa, do they have to be parents of children with settled status? And is illness the only compassionate ground that they have?
Sorry, is that the only?
Is illness, that sickness, the only compassionate ground that they have?
Again, it could vary. You could have so many situations where They could be very compelling, compassionate grounds. And yes, the person who happens to be the child, or I'm sorry, the son or the daughter, that person would more often than not would have to have at least indefinite leave to remain, right? But there are situations though, where if, take for instance, you are married, the person who does not have indefinite leave to remain is married to a British citizen or somebody who has indefinite leave to remain. If we could meet a situation where we could show who does not have indefinite leave to remain, but who's got limited leave to remain. There are times they look at the very special reasons and compelling, compassionate circumstances to conclude that, well, yes, that person could apply. But it's, again, very, very complex, very technical. Anybody who wants to do that application, you can't just put the application on. You need to actually lay out the rules, what they are, and how this situation is so compelling. Hence the reason why you are making this application. And you also mentioned the issue of illness. Yes, illness is the major reason that you could use to show compelling, compassionate circumstances. But there could be other situations too. Let me give you a good example. Take for instance, if somebody is so elderly, right? Nobody to take care of that person back home, and you can prove that that's the case, and that person, take for instance, has arthritis, for instance, serious arthritis. Nobody to be able to take care of that parent back home. And although the person came in as a visitor, under normal circumstances, if you make an application to try to actually change from visiting to, staying with your relative in the UK, under normal circumstances, it will be refused because they will say the purpose of your visit was a visiting visa, right? Not settlement. But if there are very serious circumstances, take for instance, like the example I've just given, arthritis, nobody to be able to take care of that person back home, that person will be struggling. Maybe that person also has health situations to do with, not being able to move about. Who would then be able to take care of that person back home? So that's the kind of case you would make based on compelling, compassionate circumstances, and then you then make the case of the human rights aspect of that case. That person's right to family life with their children or child in the UK is possible. Although it will be refused based on immigration rules and regulations, but the human rights aspect, we might be able to at least succeed based on that if it goes to court.
Thank you, sir. My second question. For children born here in the UK, I know that they do not have to be on any immigration status they mustn't for the first 7 years. But I've seen videos of people who say they were being charged some NHS fees when their children had to use the hospital because they didn't have any immigration, whatever. So is that true, sir?
Yeah, well, unfortunately, these days, the parents, when it comes to hospital charges, if the person does not have status in the UK, unfortunately, and of course, you will be treated by the NHS, but because of the fact that you do not have any status, the NHS would now, come back for you, even years after, for you to actually pay the fees. It would then depend on how destitute that person is, to be honest with you. If that person doesn't have the money, he or she doesn't have the money, well, you don't expect that person to go and steal, to pay for the medical bill. But indeed, it's the case that the person could be forced to actually pay for the fees, despite the fact that the child, it's to do with the child, and that child was born in the UK. It would then depend on how you then put representation to the NHS and even possibly the Home Office, if you are to make an application in the future as to why you cannot pay. The child, yes, 7 years, You could only make an application if the person is 7 years and above, but if the child is less than 7 years, it would then depend on whether you possibly even have the money to be able to do anything or to pay the NHS fees. They might possibly put you on some kind of, even if you can't pay straight away, they will say, well, you will still have to pay this in the future. Whatever you do, even if we now grant you leave to remain, you would then now need to have an agreement, with the NHS that you'll be paying instrumentally or whatever anyway, but they will still pursue you for that very particular fee. Yes.
Please, take notes. Because it's immigration matter, we are aware that is a very serious issue. Can we restrict questions to just one for each person so the time can go round? Thank you.
I have a sister that was granted limited leave to remain on compassionate ground. She came in as a visitor and she was granted that leave to remain because the husband was very poorly, dementia. Oh, bless you. the husband was, the husband had dementia and very serious one that she needs to remain to help. She came to visit, but now the husband is so ill. He's still alive, but I just want to ask this question: that if anything happened, like the husband died, will her paper be renewed? Because she's so worried and she cries every day, and we have to give her, some sort of support, reassurance, courage. And she said, I have really suffered. And if this man died, what will I do?
How long has she been in the UK?
She's been down for 4 years now. 4.5. She's about to renew. The husband is a British. So she's about to renew the paper next month. So, but she's worried because the man is so...
She came as a visitor, as she has rightly said, and then her husband took ill, and then eventually, on compassionate ground, maybe they filed an application for her, and she was granted about 2.5 years or whatever. And then the fact is that the illness of her husband, continued to deteriorate every day. And then it got to a point that the city council, the social services have to engage the services of, carers, to kind of come and, take care of this gentleman at home. The social services were so kind to the level that on the on the PRP of this very lady, they said she can walk, but no recourse to public funds. Now, the fact now is that they now looked at her, that, okay, you are taking care of your husband, okay? We are now going to allow you to be taking care of your husband on an unemployment basis. You're going to be employed as if, you are taking, and then the social services are now giving her the basic salary. And then it's like she wakes up every day, start taking care of this very gentleman. So not to cut the story short, like I said, the illness deteriorated, and then eventually they took that very man to the care home now, to the level that it's just by his grace, keep praying for this man, So the worry, like my wife has just said, for this lady was that should anything happen to this very, man, though they are legally married, she's got the marriage certificate and everything together, but she was not given, leave to remain on the basis of a spouse to a British citizen. So they only give her, leave to remain on the basis of compassionate or wherever it is. So the worry now is that we want to know if she is going to renew. Are they going to renew for her? That is number one. Then secondly, should anything happen to this, her husband, does she have any ground, to actually apply? So, thank you.
This situation, it could go. In fact, there are two things, or two options really. First of all, she was granted leave based on compelling, compassionate grounds, you say, because of the illness of the husband. How old is the husband?
In this country, I think she's now about.
No. 68, okay. I understand. Now, there are two situations here. God forbid, if anything should happen to the man today, right? She's the wife of a British citizen, right? She came in as a visitor. And the fact that she's been taking care of him for a while, she was given a 2-year. In fact, the letter, did you actually see the letter that was sent to her? I'm not sure whether that letter states that you are now given leave to remain based whatever ground, and that the first 2.5 years it will be continuous for the next 10 years. Was it written in that letter?
No, nothing like that. I've been given this concessionary ground, and you have no recourse to public fund.
Which is the case?
You can walk. You can live.
I would want you to revisit that letter.
Yeah.
Because
She sent something to me, but the phone got
because in those letters, when they actually grant 2 years, sorry, 2.5 years, when they grant the 2.5 years, leave to remain, it will then lay out all what's. And there's always this thing, you are now on a journey, a 10-year route journey towards the end of that letter or something. It's always either the beginning or at the end. So if, exactly, either 5 or 10. Hers, because she came as a visitor, it's most likely 10. But the point is, even if she came as a visitor, and she renewed before that visa expires. Oh, sorry. If she came in as a visitor, right, and she renewed that visa before the 6 months visiting visa expired, it could be 5 years because she didn't make any application beyond the visiting period. But if it was beyond the visiting period, it's most likely that it would be 10 years. Right? And they will state it in that letter. So if we have a 10-year route, right, God forbid, if anything should happen to the gentleman, she could still make the case that, look, I don't have my husband anymore. I've been here for a long time. It's most likely that the husband will be buried in the UK. I don't know what the plans are. If that's the case, she could then she could make the case that, look, I want to be where my husband is buried, right? It's a family thing, an emotional thing, a compelling, compassionate situation. And for that reason, I'm making an application just based on that. And it would also depend on, I don't know whether our children are back home, or are they here? Oh, no children together. Oh, I see. But she has children. And where are the children? Could they, how old is the lady? Okay. And could we have a situation whereby the children could take care of her back home? Well, why? Why would that be? They are not able to. Oh, I see. Okay. If that's the case, anyway, I mean, if she makes a further application for leave to remain after that, if anything should happen, it will be this. But these days, it's normally called limited. Discretionary used to be 3 years, but it's not 2.5. It will be a compelling, compassionate case under the Human Rights Act that she needs to be here. Our husband is buried here. although she's not been in the UK for 20 years, she's been in the UK for less than 20 years, but because of the situation back home, there will be insurmountable obstacles why she cannot go back. Yes, so that could be the case that she might want to make, right? Either she does it that way, or why can't she just go for a straight marriage application, spousal application here, before anything happens to the man? Did you consider that? Have you ever thought about that? It's something that could actually be, explored, because, yeah, you could tell her to go, no trouble. Okay, there's this question. Sir, if I arrived in UK in year 2020 with a student visa, can I apply for ILR in the year 2020?